Welcome back, dear students. Today we will learn the drafting of writs and what are the essential ingredients of a writ, and especially with reference to writ of habeas corpus, we will learn the essentials of a writ. So, dear students, before you start the actual drafting of any writ, you should know the law relating to the writ jurisdiction of the High Court. You know that Article 226 of our Constitution provides that notwithstanding anything contained in Article 32, every High Court shall have power throughout the territorial limits in relation to which it exercises jurisdiction, within which the cause of action wholly or partly arises, to issue to any person or authority or government within those territories directions, orders, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them. So, dear students, the abbreviation for 5 writs before you is HMPQC. H stands for habeas corpus, M stands for mandamus, P stands for prohibition, Q for quo warranto, and C for certiorari. These are the 5 categories of writs which we will learn drafting one by one. And this writ jurisdiction of the High Court is available for enforcement of fundamental rights conferred by Part 3rd and for any other purpose also. Thus, the jurisdiction of the High Court is not limited to the enforcement of fundamental rights, but also to other legal rights. Thus, power of the High Court are more extensive than that of Supreme Court, because Supreme Court has jurisdiction to issue the same 5 kinds of writs only on violation of fundamental rights, not otherwise. In this connection, we have a landmark judgment, Chandra Kumar versus Union of India, decided in 1997 by the Supreme Court, wherein it was held that the power of judiciary over legislative action vested in high courts under Article 226 is a basic feature of Constitution of India, and therefore it cannot be ousted or excluded even by way of Constitutional Amendment Act. Accordingly, Supreme Court declared Article 323 capital A clause 2 D and 323 capital B 3D as unconstitutional. Why? They excluded the jurisdiction of the high courts under Article 226 and 227. Thus, they were declared unconstitutional. Now, dear students, before drafting of actual writ, you should know who can apply for it. Who has the locus standi? Locus standi means the right to bring an action to be heard in a court on a matter. Otherwise, court will rule that plaintiff lacks the standing. To bring the suit, within the cognizance of the court, you should have a locus standi. Otherwise, your suit will be dismissed without consideration of the merits of the claim. And traditional rule is that a person whose constitutional or legal right is infringed, only he can apply for relief under Article 226. But Supreme Court has now considerably liberalized the rule of locus standi. Few public spirited persons are now permitted to file writ petitions for the enforcement of constitutional and legal rights of any other person if that person or class of persons is unable to invoke the jurisdiction of the High Court due to poverty or any other social or economic disability. Dear students, such actions are known as class actions or public interest litigation or representative litigation. When court exercises jurisdiction in public interest litigation through letters or on the basis of newspaper reporting, that is known as epistolary jurisdiction, which means acting on a letter written by or on behalf of the oppressed people. This strategy is adopted by the Supreme Court for facilitating access to justice to the masses. We have a very good example of regarding Ram Leela Maidan incident versus Home Secretary, in which Supreme Court took cognizance of the matter on the basis of newspaper reporting next day morning. Now, dear students, what is writ jurisdiction of the Supreme Court? You see, fundamental rights are given by the Constitution, but if adequate remedy is not prescribed for their enforcement, they will become meaningless. Article 32 and 226 gives the writ jurisdiction to Supreme Court and High Court respectively. Article 32 of the Constitution, is the most important article. Why? This Article 32 describes the last of the 7 groups of fundamental rights, and this right is remedial in nature and not substantive in nature. Anyone can move directly to the Supreme Court under Article 32 for the enforcement of fundamental rights under Article 32. 32 clause 1 says that the right to move the Supreme Court by appropriate proceedings for the enforcement of rights granted by Part 3rd is guaranteed. And appropriate proceeding here means, as defined in Article 32, Supreme Court, like High Courts, shall have the power to issue directions or orders or writs, including the following writs. Again, the abbreviation is HMPQC. H stands for habeas corpus, M for mandamus, P for prohibition, Q for quo warranto, and C for certiorari. So, dear students, this Article 32 gives powers to the Supreme Court for fundamental enforcement of fundamental rights only. And this power given to the Supreme Court is integral part of the basic structure of Constitution of India. And Article 226 empowers the High Courts for enforcement of fundamental rights plus other legal rights also. So whose jurisdiction is vital? Is it Supreme Court or High Court? You see, the nature of jurisdiction under Article 32 and 226 is not appellate but supervisory. But court can exercise all necessary appellate powers to do substantial justice. So as between the Supreme Court and High Court, the powers of High Court are wider because High Court can look the violation of non-fundamental rights also. Whereas the Supreme Court will entertain the writ only and only when your fundamental right is infringed. Supreme Court has another power under Article 136 of Constitution to entertain special leave petition. That power is also purely supervisory. So we have seen that locus standi rule that only a aggrieved person can file a writ has been relaxed in the shape of public interest litigations by the Supreme Court as well as by the various high courts, and now other persons can also file a writ in either in the Supreme Court or in the High Court on behalf of other persons. Now this is a summary before you, summary of the 5 writs before we start the actual drafting of habeas corpus. Habeas corpus means you may have your body. This writ is a protection against illegal detention. Mandamus means we command, positively as well as negatively. Prohibition means we prohibit. Quo warranto means show your authority. If you are holding a post, I am sure that many of you will become civil judge junior division after completion of your BA LLB. So your appointment as civil judge junior division can be challenged under writ of quo warranto. And in certiorari, we quash the order of the lower court. Then we have another writ known as curative writ, where we cure the defects in our own orders. And then finally, the power of review is also there, that we review our own orders. So these are the 5 categories of writs, and I have explained you that the power of the High Court are wider than the power of the Supreme Court. Dear students, this writ is a discretionary relief and it may be refused on following grounds. If there are laches or unreasonable delay, writ will be refused. If petitioner has misrepresented or suppressed the material facts, it will be dismissed, will not be entertained. If the writ is futile or ineffective, no relief shall be granted. Or if during pendency of the writ, respondent offers to the petitioner all the reliefs, तो compromise हो गया, then writ has no meaning. Now, with this background knowledge in mind, we will dwell upon what are the essentials of a writ. The first of all, name of the court you have to choose. Either you are going to file your writ in the Supreme Court or in the High Court. Then writ number dash dash of the year you will write down. Then heading will be under Article 32 if you are going to the Supreme Court, or Article 226 if you are going to the High Court. Then in the matter of, then you will write down the name, parentage, age and address of the petitioner. If there are more than one petitioners, then name, parentage, age and address of all the petitioners is to be mentioned in the writ. Then versus against whom you are filing this petition, name, parentage, age and address of each and every respondent is to be drafted by you. Then you will address this writ to whom? To the Honorable Chief Justice and other companion judges of this Honorable Court. Why you have included the all judges? Because you do not know before which judge your writ is going to be listed. So you have written to the Honorable the Chief Justice and other companion judges of this Honorable Court. Then petitioner above named most respectfully sheweth as a man. Sheweth means to show humbly. Then you will write down all introductory facts on the basis of which you are going to file the writ. Then you will have to show the cause of action also. Then conclusions on cause of action, emphasizing the need for issue of writ, why order should be issued in your favor. And then facts necessary for issue of interim orders also. Then dear students, you will draft certain common paragraphs as per requirement of Article 226 clause 3. The petitioner has served on the respondent copies of this petition and all the documents in support of the plea for interim orders paid therein. Then you will write down that the petitioner submits that this petition involves substantial question of law as to interpretation of Constitution of India. Then you will write down, dear students, that the petitioner has no other remedy for the redressal of injuries complained of heretofore under any other law for the time being in force. Then you will write down that the petition has not submitted any other writ or petition to this Honorable Court or Supreme Court of India in respect of subject matter of this petition. And after mentioning all these compulsory paragraphs, now you are supposed to write down the grounds of the petition. Grounds why your petition should be allowed. And lastly, the prayer. After prayer, signatures of the plaintiff are required. Then through counsel, ABC, advocate. Advocate's signature are also required. Then you will mention the place, date, and all annexures which you are going to file along with this writ. And dear students, please note down that an affidavit is also required to be filed along with each writ petition. Then writ petitions should be accompanied by this, you should know. Number 1, cover page. Page number 2, index. Page number 3, annexures as referred in the writ petition. And a court fees of ₹500 per petitioner is payable in Supreme Court. If there are 4 petitioners, you are supposed to pay 2,000 rupees court fee. But in criminal matters, no court fee is paid. And then affidavit of the petitioner duly sworn before notary public has to be filed along with the writ petition. And if you have any interim application, if you have moved an interim application for stay order, then any application to be filed, rupees 120 court fee per application is to be paid. Then memo of appearance. If the accused is in jail and writ is to be filed before the High Court or Supreme Court, then memo of appearance is to be filed. If the client is outside the jail or it is a civil matter, then wakalatnama or special power of attorney is to be filed in favor of an advocate. Then if you are filing an application seeking permission to appear and argue in person, you have taken the degree of law, you are an advocate. If it is your personal matter, you can argue yourself. But you will have to move an application along with the writ seeking permission to appear and argue in person. On this also you will have to pay court fees of rupees 120. And the rules framed by the Supreme Court, are separate for payment of court fees, and rules framed by the various high courts are different for payment of court fee from state to state. Now, dear students, we quickly come to the drafting of habeas corpus writ petition. Habeas corpus means you may have the body. It is a process by which a person who is confined in jail without legal justification may secure a release from illegal confinement. This writ can be made by any person on behalf of the prisoner as well as by the prisoner himself. There is a leading case, Upendra Bakshi and others versus State of UP, decided in 1983. Upendra Bakshi, sir, was our professor of law when I was doing LLM at Delhi University. He filed a public interest litigation under the heading habeas corpus for release of inmates, ladies from Agra home. The writ of habeas corpus, dear students, is an effective means of immediate release from unlawful detention, whether in jail or in private custody. The right to life and liberty of inmates under Article 21 is violated if inmates are living in inhuman and degrading conditions in Agra home. Dear students, the general rule is that this writ can be filed by the person who is illegally detained. But in certain cases, this writ can be filed by any person on behalf of a prisoner. Any one of his friend or relative can file this writ. And the example is Sunil Batra versus Delhi administration, wherein a letter addressed to Supreme Court alleged that torture was being practiced upon another prisoner, Premchand. This was treated as a writ of habeas corpus, and it was held that writ of habeas corpus can not only be used for releasing a person illegally detained, but it will also be used for protecting him from treatment inside the jail. So the rule of locus standi is relaxed in such cases. We have very glaring example of Rudul Shah versus State of Bihar. In this case, additional compensation of rupees 30,000 was paid for illegal detention in a writ of habeas corpus. Mr. Rudul Shah was detained for long 14 years, even after his acquittal by the competent court, as his liberty was violated. His release order was sent at the district jail. It was received in the district jail, but still he was not released. And he was released when a writ of habeas corpus was filed on behalf of Mr. Rudul Shah. Now, dear students, we will draft a writ of habeas corpus. You should take up this exercise and draft a writ of habeas corpus based on some imaginary facts. All right? Facts which I am giving you for the moment are that Ram and Sita are husband and wife. Sita underwent family planning operation after having 2 children at Preeti Nursing Home, Sector 128, Noida, District Gautam Buddha Nagar, UP. But the operation failed. The owner of the hospital is real brother of ex-DGP of Police, UP. Ram wants to initiate legal proceedings against the owner of nursing home. In the meanwhile, the hospital management requested Ram not to do so When Ram did not accede to their request, they threatened Ram of dire consequences. 2 days after this incident, 5 persons came to the residence of Ram and fished him away. Since then, his whereabouts are not known. While Ram was taken away, Sita was at home. 5 persons who fished away Ram did not disclose their identity, but they were in police uniform. Sita and her relatives tried to trace out the Ram, made a search for him in all the police stations and other places, but in vain. Now Sita wants to file a writ of habeas corpus against state of UP for production of the body of her husband. Now you are supposed to draft a suitable writ petition on behalf of Sita. So first of all, you will draft the name of the court in the High Court of Judicature at Allahabad, writ petition number dash dash of 2017, special original jurisdiction under Article 226 of Constitution of India, between Shrimati Sita, wife of Ram, with complete address, and she is the petitioner, and this petition is filed against state of UP. They are respondents. So you are addressing this writ to Honorable Chief Justice and all the companion judges of the Honorable Court. The petitioner above named most respectfully showeth as under Para 1. The petitioner above named is the wife of Shri Ram, whose whereabouts are not known, and is as such well conversant with the facts and circumstances of the case. Para 2. The petitioner most humbly submits that her husband Shri Ram was taken away by 5 unknown persons, claiming to be the police officers on 1/1/2017, without assigning any reasons or without informing any other details, in spite of requests made by the petitioner. The husband of the petitioner did not return home till late night on that day, and petitioner, along with her relatives, made inquiries about the whereabouts of her husband, not only in nearby places but also in the nearby police stations, but of no avail. Para 3. The petitioner most humbly submits that 5 persons who have taken away her husband are undoubtedly the police personnel, inasmuch as 2 days prior to this incident, few people claiming to be partners in Preeti Nursing Home came to the residence of petitioner, asking her husband not to go ahead with the filing of legal proceedings against the said nursing home, failing which her husband has to face adverse consequences. Para 4. The petitioner most humbly submits that the petitioner had undergone a tubectomy operation for adopting small family norms at Preeti Nursing Home on 20th December, and operation failed, and the petitioner got pregnant. Thereafter, petitioner and her husband decided to initiate legal proceedings against the owner of said nursing home. The people of Preeti Nursing Home who had come to the resident of petitioner, they had tried to convince them not to file the legal proceedings against the owner of Preeti Nursing Home. They also informed the petitioner that she and her husband should not file a case against owner of Preeti Nursing Home, because he is the real brother of ex-DGP of Police UP. As such, the petitioner believes that her husband was taken away by the police personnel at the instance of owner of Preeti Nursing Home, in connivance with ex-DGP of Police UP, in retaliation to our move of filing a case against them. Para 5. That the husband of petitioner is working as chief reporter in the APN news channel Sector 63 Noida, and he has neither any bad habits nor he is indulged in any antisocial activities, and there are no civil or criminal proceedings either contemplated or pending against her husband, either in this state or outside the state. Para 6. That it is most respectfully submitted that the husband of the petitioner is the only earning member of the family, and in his absence, petitioner and her 2 minor children and near and dear relatives are facing a lot of mental agony, frustration, and disappointment. The petitioner is in doubt that there may be threat to the life of her husband. Hence, this writ petition is being filed inter alia on the following grounds. So now you will mention the grounds of your writ one by one. The first ground is that taking away of the husband of the petitioner from her residence without any reason, cause, or without any intimation or further details is illegal, arbitrary, and against the constitutional guarantees and settled principles of law and judicial decisions. The police personnel who have fished away the husband of the petitioner have not followed any of the procedure, rules, guidelines as laid down in the CRPC and also laid down by Supreme Court from time to time. Second, that the local police and district administration indulging the state has failed to trace out the whereabouts of the husband of the petitioner since last 10 days, and there is every possibility of a real threat to his life in the hands of the police on the instigation of the owner of Writ Nursing Home. Para third, ground third, that in the absence of the husband of the petitioner, her children, and other friends and relatives are suffering from uncalled mental agony. Para 7, that the petitioner most humbly submits that the petitioner has no other effective alternative remedy except to invoke the extraordinary jurisdiction of this honorable court under Article 226. Para 8, that the petitioner most humbly submits that the petitioner has not filed any other writ, suit, or other proceedings either in this honorable court or in any other court of law or authority in respect of this subject matter. In view of foregoing facts and circumstances of the case, it is most humbly prayed that A, this honorable court may be pleased to issue a writ of habeas corpus or any other appropriate writ, order, or direction, directing the respondents to produce the husband of the petitioner, Shri Ram, before this honorable court, and on such production to release him without any bond or security, and to pass such order or further orders as this honorable court may deem fit in the facts and circumstances of the case. You will have to mention the date, and then signature of petitioner are required, and then the counsel who has filed this petition, you will write down through counsel ABC, advocate, his signatures are also to be appended at the end of this petition.